Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Today we from group 2 are going to present one of the topic covered under the criminal procedure law, which is search. So our group consists of 5 members, which are first I myself Ahmad ZAIM SUHAIL bin Ahmad MUJAHID, second AHMAD IDHAM BAIHAQI bin AZMAI, third Muhammad AIMAN FARIQ bin Muhammad YATIM, fourth NADHRAH BAHIYAH binti ARMAN SHAH, and fifth NURUL ASYIKIN binti ABDUL HADI. So first of all, what is the meaning of search? Basically, search is another power given to the police for investigation of criminal offences. And in Malaysia, we have Criminal Procedure Code, where it is a statute that provides general provision as regard to search. Today, we will be discussing on what are the provisions relating to the search under the CPC. The purpose of search is to obtain incriminating evidence, and under the CPC, search can be divided into 2, which are first, search of person, and second, search of premises.
The first type of search is search of person. There are several provisions pertaining the search of person. First, Section 17 of Criminal Procedure Code provide regarding search of person in place, search under warrant. Whenever a search for anything is or is about to be lawfully made in any place in respect of any offence, all persons found therein may be lawfully detained until the search is completed. Second, mode of searching woman is provided under Section 19 Clause 2 of Criminal Procedure Code. Whenever it is necessary to cause a woman to be searched, the search shall be made by another woman with strict regard to decency. Third, Section 20 of Criminal Procedure Code state about search of person arrested. Under this provision, when the arrest is made by a private person, the police officer to whom such private person hand over the person arrested may search such person and place in safe custody all article other than necessary wearing apparel found upon him, and any of those articles which there is reason to believe were the instrument or the fruit or other evidence of the crime may be detained until his discharge or acquittal. Next, Section 21, Power to seize offensive weapon. Under this provision, the officer or other person making any arrest under this code may take from the person arrested any offensive weapons which he has about his person, and shall deliver all weapons so taken to the court or officer before which or whom the officer or person making the arrest is required by law to produce the person arrested. Lastly, Section 22 of Criminal Procedure Code provide regarding search of person for name and address. Under this provision, every person lawfully in custody who by reason of incapacity from intoxication, illness, mental disorder or infancy is unable to give a reasonable account of himself may be searched for the purpose of ascertaining his name and place of abode. Section 28 of Criminal Procedure Code provide pertaining procedure for search. Any search of a person shall comply with the procedure on body search as specified in the 4th schedule of this code. Moreover, the provision of the 4th schedule shall apply to any search of a person conducted by any officer of any enforcement agency conferred with the power of arrest or search of a person under any law. The example of procedure for search is the first pat-down search. This type of search is based on patting the outer clothing of the person arrested. The circumstances in which it may be conducted is first at the time of arrest or before the arrested of person is put into custody in detention center. The second example of procedure for search is strip search. This type of search involving the removal of the entire person arrested clothing. This type of search may be done part by part. As example, by allowing person arrested to dress his upper body before removing item of clothing from his lower body.
Next is regarding to the search of premises. Search of premises may be conducted with or without warrants depending on the circumstances. First and foremost, search of premises without warrant. Refer to Section 62 of Criminal Procedure Code. There are certain conditions that must be fulfilled before a search of premises is conducted. Firstly, information must be received by the police officer not below the rank of inspector. Secondly, the information relates to a reasonable cause to suspect that the stolen property is concealed or lodged in private place. Next, that officer has a good ground for believing that by reason of the delay in obtaining a search warrant, the stolen property is likely to be removed. After that, a person from whom of the property alleged to have been stolen, and the informant has good grounds for believing that the property is deposited in that place. And the last condition is, the person from whom the property was stolen or his representative shall accompany the officer in search. Besides, according to Section 62A of Criminal Procedure Code, where the inspector and above may search premises without warrant for counterfeit coins or counterfeit current coins or any die, instrument or material for the purpose of counterfeiting any coins or current coins. Meanwhile, Section 62B of the Criminal Procedure Code is regarding to the forfeiture of counterfeit currency, where the inspector and above may, without warrant, search premises for any forged or counterfeit currency notes or bank or any machinery, instrument, or material used or intended to be used for the forging or counterfeiting of any currency note or banknote. Moreover, based on Section 63 subsection 1 of Criminal Procedure Code stated that any police officer may enter any place in search of stolen property and search, seize, and secure any property which he believes to have been stolen. However, he has to be authorized in writing by the Chief Police Officer in order to do so. Section 63 subsection 2 of Criminal Procedure Code then stated that in every case in which any property is seized in pursuance of this section, the person in whose place it was at the time of seizure, or the person from whom it was taken, if other than the person in whose place it was, shall, unless previously charged with receiving the same knowing it to have been stolen, be summoned before a magistrate to account for his possession of the property. And the magistrate shall make such order respecting the disposal of the property, and may award such cause as the justice of the case may require. Furthermore, according to Section 64 of Criminal Procedure Code, a list of all things seized in the course of a search made under this chapter, and of the places in which they are respectively found, shall be prepared by the officer or other person making the search and signed by him. Lastly, Section 65 of Criminal Procedure Code, where the occupant of the place searched or some person in his behalf shall in every instance be permitted to attend during the search, and a copy of the list prepared and signed under the section shall be delivered to the occupant or person at its request.
Next is search with warrant. Under Section 54 of Criminal Procedure Code, the court may issue a warrant where any court has reason to believe that a person to whom a summons under Section 51 or a requisition under subsection 52 clause 1 has been or might have been addressed will not or would not produce the property or document as required by the requisition. Besides, the court may issue a warrant where a property or document is not known to the court to be in the possession of any person, or the court considers that the purposes of justice or of any inquiry, trial, or other proceeding under this code will be served by a general search or inspection. However, nothing herein contained shall authorize any court other than the High Court to grant a warrant to search for a postal article, telegram, or other document in the custody of the postal or telegraph authorities. Next, a search warrant shall ordinarily be directed to the Chief Police Officer as stated in Section 54 subsection 3 of the Criminal Procedure Code and Section 54 subsection 4. The court may issue a search warrant to a named private person nevertheless. Other than that, Section 55 of the Criminal Procedure Code is regarding to the power to restrict search warrant where the court may specify in the warrant the particular place or part thereof, and the person charged with the execution of the warrant shall then search or inspect only the place or part so specified. In regarding to the form of search warrant, it can be referred to Section 57 of Criminal Procedure Code, where every search warrant issued by the court shall be in writing and shall bear the seal of the court. Besides, every warrant shall also remain in force for a reasonable number of days to be specified in the warrant. And lastly, search warrant issued under this code may be executed in any part of Malaysia. There is a case that can be referred to in Lamchia against Public Prosecutor, where the warrant was issued on November 3, 1984, but was executed only on November 8, 1984. The High Court had to construe the meaning of every such warrant shall remain in force for a reasonable number of days to be specified in the warrant, appearing in Section 62, Subsection 2 of the Copyright. It was held that the requirement of time period for the warrant to remain in force is merely directory and not mandatory. Thus, it was not fatal that no period being specified in the warrant.
Seizure. Seizure is the forcible taking of property by a government law enforcement official from a person who is suspected of violating or is known to have violated the law. For example, the police may seize a pistol in the coat pocket of a person arrested during a robbery without presenting a warrant. Types of seizure. There are few specific and general provisions regarding the seizure. The specific provisions are in the section 56, 62A, 62B, and also 63 of Criminal Procedure Code. General provisions are in section 54 and section 435 of Criminal Procedure Code. Seizure would embrace the taking of things by the officer conducting the search. If there is a specific provision under specific statutes provide for the matter of seizure, then the seizure must be governed by such specific provision. Otherwise, reference need to be made to the general provisions of section 435 of the Criminal Procedure Code. In section 435 of Criminal Procedure Code stipulates that any member of the police force may seize any property which is alleged or may be suspected to have been stolen or which is found under the circumstances which create suspicion that an offence has been committed, and such member, if subordinate to the officer in charge of the nearest police station, shall forthwith report the seizure to such officer. Continue in section 63 of Criminal Procedure Code is stated that any police officer authorized in writing by the chief police officer may enter, search and seize any property believed to have been stolen. The chief police officer may give such authority if the place to be searched is or within the proceeding 12 months has been occupied or used by any person who has been convicted or receiving stolen property or is occupied or used by any person who has been convicted of an offence involving fraud or dishonesty and punishable by imprisonment.
Now, there is an issue arises here relating to the seizure. The issue is whether a police can seize the items which are not listed in search warrant during search. The answer is yes, the police can seize those items as long as they have reasonable grounds to do so. This can be looked in the case of Chic Fashion Westwell Ltd vs Jones, where in this case, the police were authorized by a warrant to search a shop belonging to the plaintiff for goods stolen from Iron Peters Ltd. When they went to the shop, they searched the premises but they did not find any of Iron Peters Ltd goods, but they seized goods of other makes of the kinds which have been stolen and which they thought were stolen. And the plaintiff then claimed damage for trespass from the police. In this case, the court held that the action that had been done by the police is lawful, and Lord Denning stated when a constable enters a premises under search warrant for a stolen item, he may seize not only the goods which he reasonably believed to be covered by the warrant, but also other items which he reasonably believed to be stolen. Next, we can look in the case of Kahwai Video Ipoh Sendirian Berhad, where in this case, High Court held that the magistrate who issued search warrant had neither the power nor the authority to direct the return of the unscheduled articles seized by the police to the owners. We can also refer to in the case of Ghani and Another versus Stones. So, here we can see that the principle is the police can seize the items which are not listed in search warrant during the search. However, they must have reasonable ground to do so.
Illegally obtained evidence. Illegality arising in many aspects of the entry, search, seizure, and disposal of the seized items will not vitiate any criminal prosecution. Based on the decided cases, illegally obtained evidence is admissible in law. However, the court retained a discretion to exclude such illegally obtained evidence, taking into consideration to what extent it would operate unfairly or oppressively against the accused. According to Krumah vs. Regina case, Lord Goddard Judge stated that the test to be applied is whether the evidence is relevant to the matters in issue. If so, the evidence is admissible. The court is not concerned with how it was obtained. In the case of King vs. Queen, the court held that although the search is illegal, but the court has discretion whether to admit illegally obtained evidence or not.
As a conclusion, search is one of the important parts in criminal procedure. There are two types of search, which are search of person and search of premises. There are also few types of seizure stated above and admissibility of illegal obtained evidence. We have added the relevant facts, the relevant case, the relevant authorities, and the relevant statutes that were relating to this topic. So I think that's all for our presentation this time. So thank you.